seat, please. Welcome to these proceedings of the First District Court of Appeal. We have 3 cases on today's docket. For the information or the use of the advocates, we'll be moving through these cases in the order in which they appear on your dockets. And the court, the 3 of us have decided to move straight through without taking a break unless that should become unnecessary for some reason that is unforeseen. First case on today's docket is W. Frank Wells Nursing Home versus State of Florida Agency for Health Care. We're here for the appellant.
Good morning, and may it please the court. I'm Laura Beth Ferragasso with the Henry Buchanan Law Firm in Tallahassee. I'm here this morning on behalf of Frank Wells Nursing Home, and if I may, I would like to reserve 4 minutes for rebuttal.
Watch the clock, please, Ms. Ferragasso. The light will change.
I surely will. Thank you, Judge. We're here this morning, Your Honors, on a matter that may seem somewhat trivial as a matter of practicality, but which the appellant views as certainly not trivial, but rather a significant issue of due process. As the record reflects, the Agency for Health Care Administration issued a deficiency notice and Class 3 citation under Chapter 400.23, the Nursing Home Licensure Statute, to Frank Wells Nursing Home, asserting that the nursing home had violated the transfer rules governing a patient who was Baker Acted. The nursing home disagreed with the citation and protested that the agency's underlying facts were incorrect. After some period of time, the agency filed a Chapter 120 petition for hearing, and the agency denied that hearing. You
mean your client filed a Chapter 120?
I beg your pardon, the nursing home.
Is the timing of that at all an issue in this case?
I don't believe the timing is at issue at all, Your Honor. I can discuss reasons for that in just a moment. The nursing home filed a petition for a 120 hearing. The agency immediately issued an order denying the petition for hearing and dismissing it with prejudice, citing as its only authority an administrative final agency order and Chapter 120.57, saying that its actions were investigative in nature and not considered final agency action. The nursing home appealed, and that is what brings us here today. As a first point, I would suggest that the reasoning given for the dismissal is facially incorrect, and in fact, in its answer brief, the agency did not even cite the agency order which it used in support of the dismissal with prejudice. The issuance of this deficiency was an act of adjudication. It was certainly more than an investigation into facts, as the agency's order would suggest. It concluded with a disciplinary citation and thus was in fact an agency action which impacted the nursing home. The agency subsequently argued that its dismissal was with prejudice was nonetheless appropriate because Frank Wells had not in its petition indicated any substantial interest that was impaired as a result of the citation. At the outset, let me say that on appeal was the first time that Frank Wells had been informed that this was the basis of the agency action, which clearly is a violation of Chapter 120.569, which requires that any dismissal state with particularity the reasons for the dismissal. But in addition to that, the agency's position overlooks the fact that Rule 28-106.2015 which governs disciplinary actions and enforcement actions by any state agency, expressly says that any communication of any discipline, not necessarily one that imposes a fine or some other more substantial penalty, any communication of any discipline imposed by an agency with enforcement power is the functional equivalent of an administrative complaint.
Counsel, under Chapter 120, what injury did the statement of deficiencies cause to your client?
Judge, the statement of deficiency was issued pursuant to Chapter 400.23, which is the Nursing Home Licensure Statute. That statute requires the agency to make periodic inspections of nursing homes. Upon making those inspections, the agency then imposes a licensure status. You're either given a standard licensure status or a conditional status. In this case, we received the conditional status because there was allegedly a Class 3 violation which which at the time was not corrected and which required a corrective action plan. The nursing home, of course, would suggest that because it views the underlying facts as being misinterpreted by the agency, that a corrective action plan was not necessary. But nonetheless, that requirement was imposed, the conditional licensure status was imposed, and once a conditional licensure status is imposed on a nursing home, that information is required to be reflected on the license, publicized in a highly visible area in the nursing home itself. It's put on the website that the agency maintains for comparative purposes for nursing homes. It potentially subjects the nursing home to financial penalties or other penalties down the line. And so as soon as that conditional licensure status and citation were imposed, Frank Wells had an injury, in fact. Again, however, we would suggest that under Rule 28-106.2015, it was not necessary to specifically allege the injury in the petition.
Counsel, you referred to Section 400.23 Florida statutes. Under Section 400.23 Florida statutes, isn't the determination of compliance a preliminary step to the agency's assignment of a licensure status?
I'm sorry, Your Honor, would you repeat the question?
Again, under Section 400.23 Florida statutes, isn't the determination of compliance a preliminary step to the agency's assignment of a licensure status?
Your Honor, my understanding is that once the citation is issued, it is mandatory for the nursing home to prepare a corrective action plan, and in the absence of a corrective action plan that satisfies the agency, then that conditional status is maintained. It's not my understanding that it is a preliminary action. And in fact, the mere requirement for a corrective action plan to be filed does in fact place a burden on the nursing home, which in this case we would argue is unwarranted in light of our dispute of the underlying facts.
At this stage, what remedy does your client expect from the administrative hearing?
Well, Your Honor, I think at a minimum, if the court were to determine that the petition simply did not allege substantial interest being impaired, at a minimum, the agency is required to allow the appellant to amend its petition and state substantial interest being impaired. However, it's our position that under Rule 28-106.2015, that statement of substantial injury is not required, and thus the agency should be deemed to have filed an administrative complaint and should give an evidentiary hearing as requested. So either way, we believe that the nursing home is entitled to go forward with its protest of the disputed facts at issue.
What would be the outcome of that hearing if you won? They'd be forced to remove the notice of deficiency?
That's correct, Your Honor.
Wouldn't be like in the case of a filing of a complaint, which would be dismissed. I think this is the question. I mean, nothing's filed yet. You're just sort of removing this negative comment from your record, essentially. Is that it?
Well, it's a removal of the negative comment or the citation, but it's also a correction of the information that is publicly disseminated about this alleged violation to
Well, let me ask you, is that, there's some discussion of this point in the briefs, but is that by your argument, the only injury that your client has suffered a reputational kind of a loss because this has been posted and been made known? Is that all it is?
Well, Your Honor, certainly there is a loss of business goodwill. There is.
I'm not saying that's insignificant.
Right.
I'm just trying to narrow it down to see if there's something else that, because, you know, there's an argument about the stigma plus all that. I mean, and so I guess what I'm trying to find out is if this is just a reputational injury.
The primary injury certainly would be reputational. I am aware that the stigma plus test requires more than mere injury to personal reputation. However, under Florida law, the reputational injury in a commercial setting plus loss of business goodwill or plus lack of truthfulness satisfies that test. But those are the injuries that would be most manifest, and of course we don't.
Well, so that I'm sure that I understand this now, your argument on this particular point is, in this context, that kind of an injury would be enough.
Yes, it is.
Okay, I think I understand your point.
Yes, and thank you. I'm into my rebuttal time as well.
Thank you.
Have a seat. Thank you.
Good morning, and may it please the Court. My name is Thomas Huller, and I represent the Agency for Healthcare Administration. First, I think that it should be pointed out that the petition for hearing that was filed by the nursing home in this case contains no allegation of any type of injury, in fact, at all. The only thing that this facility received was a statement of deficiency.
Well, if counsel is correct, though, in her response to Judge Padovano's last question, wouldn't the allegation that the nursing home has received a citation for Class 3 deficiency suffice?
No. A Class 3 deficiency it's not even a violation.
Isn't that a question of law, though? I'm talking in terms of a factual allegation of standing, which they say they weren't on notice they hadn't made anyway, which I'm sure you would concede they would be entitled to amend, I suppose, if it could be amended. But isn't the question that was before us right now, whether a Class 3 deficiency is an injury of fact, in fact, isn't that a question of law?
There's no such thing as a Class 3 injury.
Class 3 deficiency, I believe is.
There's an allegation, there's a statement of deficiency in which they've been cited they haven't even been cited for a Class 3 deficiency. That's the problem. Class 3 deficiency requires two citations. First, you get one violation or one citation, and you can't even be fined yet. It's not a violation until you commit a second Class 3 deficiency.
Well, you just said a Class 3 deficiency is not what now? I think you even said
it's not an injury.
I think you said they haven't even been cited for a Class 3 deficiency. I don't know if you meant to say that, but I think you just said that.
A Class 3 violation encompasses two deficiencies. You must commit a Class 3 violation at one time. You are given 30 days to correct it. If you correct it within the 30 days, it's not a violation. It's not even something that we can impose a fine for.
No, but my question was, and maybe I misheard or maybe you misspoke, is whether you said earlier on, maybe a minute ago now, whether they are not even cited for a Class 3 deficiency. That's not an issue, is it?
That's not an issue.
They were cited for a Class 3.
They received a statement of deficiencies which says that they committed an act which we determined to be a Class 3 deficiency. Okay. It's not a violation yet because they haven't committed the second act within a certain time period. They have 30 days to correct it. If they correct it within that time period,
Well, what should a nursing home do in this situation? Suppose that I represent a nursing home and you send me one of these notices and I vehemently disagree with it.
yes.
I don't think it's factually supported. What should I do?
What I would do is I would write a letter or actually pick up the phone and contact the field office manager in the area and say, look, I've received a Class 3. I received a statement of deficiency saying that I've committed the Class 3 Act. I disagree with it. I would like to take this up with you. At that point, the field office manager can look at the facts, speak with the surveyor, and then if the field officer manager determines that the surveyor was incorrect, they can revise.
Let's suppose that the field person sticks to his or her guns and says, nope, I'm sticking with this, I don't care what you say. Now what does a nursing home do?
The nursing home, if they feel that strongly about it, if they have an injury, they can file a petition for hearing.
Well, that's what they do.
But they don't have an injury. That's the problem. They have to show that they've been injured somehow.
But, counsel, assuming that the petition failed to allege a substantial injury, couldn't that defect have been cured by an amendment to that petition?
Not in this particular case. In some cases, yes. In the Menor Manor decision, yes. Not in this case. Menor Manor was different because Menor Manor involved a deficiency that went to a food violation. And it was a Jewish facility, and when they received this food violation, they felt that they were immediately hurt. They alleged damage to reputation. That allegation didn't suffice under this court's decision.
But in that case, didn't this court specifically reject the agency's contention that a Form 2567 can never be the subject of a Chapter 120 of 157 proceeding?
That was the argument that was made then, and the court did reject it. That's not the argument that we're making here.
But how do you reconcile that reasoning of the order of dismissal with this case?
In this case, unlike in the Menor Manor decision, one, you have a difference in the type of violation. In Menor Manor, it's a food violation. And a food violation for a Jewish facility that served strict kosher food was something that they felt hurt their business immediately.
Hurt their reputation. Isn't
Yes.
that's the only thing they alleged in Menora Manor was an injury to reputation, isn't it?
Yes.
Okay.
And that was insufficient in that case. This case doesn't involve a food violation. This case involves a Baker Act violation. For a facility who receives a statement of deficiencies, if they want to correct their violation for Baker Act, they probably need to do nothing more than to revise their policies.
What if they disagree with you, though? What if they think they have followed the Baker Act?
If they feel that strongly about it, and they've gone to the field office manager, and that doesn't work, and they don't have an injury, so they can't avail themselves of this, my suggestion would be that they petition for a declaratory statement. And they should probably want to include several agencies, because that tells me that they don't know how to Baker Act people.
Well, if they did nothing to correct the deficiency, as you say, what would be the result?
If they did nothing, and the agency, we will revisit the place within 30, we give them a certain amount of time to correct their deficiency, we revisit them. If they don't correct it, we can cite them again, and at that point, we will seek, they have a Class 3 violation at that point.
You'll seek enforcement at that time.
Right.
But you don't have to seek enforcement at
We
that
don't
time.
have to.
Now, let me ask you this question. Let's suppose you don't seek enforcement. Let's suppose they do nothing, you don't seek enforcement. And now let's suppose in 2 or 3 years later, the agency is disciplining the nursing home for some unrelated conduct. And the question is, what penalty should be imposed? Can you go back and consider this deficiency on the issue of the penalty?
No. There's a certain amount of period of time in which the violation will just disappear on its own. You have an uncorrected violation, which usually is about, they get 30 days to correct. If they correct it, there's no violation. They can be cited for a repeat violation, but the outside scope of that is 2 years, so we can't look at 3 years. And it does have to be a repeat of the same violation. I can't cite them for a different type of Class 3, a food violation 1, a Baker Act here, and say, oh, these are 2 Class 3s. No, we can't do it that way. It has to be the same type of violation.
No, but what I'm asking is not whether you can pursue that, but whether or not these deficiencies essentially go down as negative comments on the nursing home's record, and then there can be used to determine what the penalty is. Let's say they commit some other violation in the future, some real serious violation, and the question is, are you going to suspend their license or are you going to revoke it? Now are you going to say, well, I lean toward revocation because after all, they had all these deficiency notices?
No. For us to do that, if we have a serious violation, it will stand on its own. If they get a pattern of violations, and they accumulate them over a period of time, then that might be able to establish some sort of basis for their licensure action. But in order to establish a pattern of violations, I need to have a Class 3 violation, which means a deficiency at point A and a deficiency later at point B sometime.
Yeah, but I take it by your argument, though, you could have this pattern of violations which are not subject to any sort of litigation because they have no injury.
Well, we don't have a pattern of violation yet, but there are instances, and I know there are instances when we have Class 4 violations, which are even lesser in degree. There somebody could commit a Class 4, then later commit a Class 4, and the field office manager simply issues no request for sanctions, doesn't want to fine them because the amount of the fine is truly insignificant, and it might be a facility that's got an excellent reputation. So that's just almost like prosecutorial discretion. We just say, no, that's just not good enough. I mean, that would be a case in which somebody might be doing, exceeding the speed limit by 4 miles per hour, and the police officer says, I'm not going to stop that person because it's only 4 miles per hour. In the case here,
if this were to ripen into a Class 3 violation by virtue of them taking the position, say they acceded in your position, this is just an investigation, we disagree with them, we're not going to do anything, and it ripened then into a Class 3 violation, I think you've said the agency would then have discretion to do nothing or to file a petition for sanctions or enforcement.
We would have the choice to file an administrative complaint.
But let me ask you the next question, though, counsel. If the agency said, well, it's just a Class 3, and maybe, we think they're wrong, it has ripened because they haven't done anything, therefore we're not going to take any action other than notifying them that they are now guilty of a Class 3 violation. My question is, would you still be taking the same position on behalf of the agency that they don't have standing at that point?
Yes. If they would come back tomorrow and we say, you don't know how to Baker Act people, here's another Class 3. So now we would have the basis for a repeat violation. But the agency, the field office manager says, for some reason or another, it's a year and a half, a year and 8 months, that's close enough. I'm not going to say it's a repeat violation. So they get another statement of deficiencies. They're in the same boat that they are now. There's no fine, there's no licensure action, there's nothing. And I would like to say something here, too, about this conditional licensure status that I've never heard about until today. When the agency wants to impose conditional licensure status on somebody, the way I filed those administrative complaints is that the conditional license is actually attached to the administrative complaint, and when the correction is made, a standard license is issued, and the standard license is also issued attached to the administrative complaint. I've not heard anything, in this case, seen anything to say that there was a conditional license issued to this facility for this violation.
Is this kind of regulation done in other agencies, to your knowledge, or is it unique to ACCA? Because, it sounds to me like you could look at this in a way that it is a method of imposing some kind of disciplinary control over an agency or a person that is regulated without it being subject to any sort of judicial review or administrative review.
The only thing that I can think of, don't know everything about every agency, but to me, it's like a police officer, a traffic officer giving somebody a warning. A warning. Here's your warning. I think that you did something wrong. And then somebody turning around, taking that warning and say, I want to go to the United States Supreme Court with this. And it just makes no sense to me. The whole point of Class 3 violations...
Counsel, given these sort of facts, even when you file a complaint in court, many times the court gives you the opportunity to amend that complaint and dismiss it without prejudice, in effect allowing you the opportunity to amend. Why shouldn't the agency have been given the opportunity to amend their petition in this case?
In this case, in fact, because of the underlying violation and because of the 6-month time that the facility waited to petition this court for a hearing, because one of the elements that the petitioner, the party seeking a hearing, must satisfy is the immediacy of injury. And they've waited 6 months. That's probably 6 times the amount of time that they were given to correct this deficiency before they even filed their petition. And now we're a year and a half out. They didn't allege anything in their, they didn't even attempt to allege any injury in their petition. They didn't seek any type of, after the final order was issued, they didn't question it or attack the final order by suggesting that the final order should be vacated and that they would like to have an opportunity to amend their petition. And they didn't even say anything in their initial brief. They're stretching to find some sort of injury, and it's just not there. So I don't see why we should allow them to amend this petition, which isn't going to say anything, allege any type of injury. It's almost an exercise of futility. So, back to your question, it's the traffic ticket is about the only type of situation where I could find. In the federal court, the federal case that I cited, I think the Villarosa case, it talks about how in the federal government, they don't see this type of deficiency being something that somebody would be entitled to a hearing. And it should be pointed out in this case, as compared to Menora Manor, the facility was cited for both at the federal level and at the state level. So they had a 2567 and a 3020. Here, these people were cleared at the federal level. So they don't even have a federal violation. They're only at the state violation. So if we could liken it, if there is an analogy, I would say it's to that federal level where they don't grant hearings on statements of deficiencies either until the CMS is actually seeking some sort of civil monetary penalty against the facility or taking some sort of action against them. Until there's some sort of action, there's nothing for us to decide. And quite frankly, I think, thinking back to what you said earlier, I don't know what the ALJ would decide in this case. And if the case goes back to the Secretary, what does the Secretary do? What does the final order say? Rather than to say, well, we think there was a violation, you've satisfied step one to a possible class 3 violation in the future. And I think it also lends itself, aside from the waste of resources, I think it does lend itself to judge shopping. So if somebody files a petition for a hearing in the first case, if they don't like the judge that they get, they can withdraw their petition, and if they commit a violation later, they can go before a different judge.
Counsel, the agency was required to post the statement of deficiencies, right?
The facility is required to post it. Our statement of deficiencies are public record after a period of time. I don't believe we post them on our website, though. I don't know exactly how that works, where the statement of deficiencies are posted or located.
But the appellate was required to post the statement of deficiencies on theirs.
Sometimes I believe they are required to put them, they're required to keep them at their facility. I don't know if they have to post them, but they're required to keep them. But once they're corrected, that all changes. And that goes back to the timing, because they had 30 days to correct this deficiency, and if it's corrected within that time, they don't have to take old statement of deficiencies and put them up on their wall. And so if they had any type of problem, it was very temporary, and if corrected, it just vanishes.
Assuming they were required to post the statement of deficiencies at their facility, would that be the type of injury that would be required to step forth?
No, because that only goes back to reputation again, because that's the only thing you have in your statement of deficiencies. And it's not an adjudication. I see my light is red. Thank you.
Council's response to, I believe it was your question, Judge Padovano, about what is a nursing home to do, precisely demonstrates the due process concern that Frank Wells has. The response was, well, if you don't agree with the facts that we've determined, call our field officer. Well, the problem is that the field officer is an employee of the agency, not an independent fact finder, and that is what due process requires. The additional response of, well, nothing's really going to happen except that you're on the hook for 2 years in case you have a repeat violation, demonstrates the injury to the nursing home of having this negative mark, this deficiency citation on its record. With regard to the concern about the delay in filing the petition for hearing, I really believe that's a non-issue. Assuming the court agrees with the appellant's argument that we are traveling under Rule 28-106.2015, and that this communication of disciplinary action should be deemed an administrative complaint. It did not give the nursing home a point of entry. And, of course, failure to do that renders the agency action ineffective. Additionally, there is an opportunity to argue equitable tolling, which might, for instance, be appropriate if in the interim the parties were trying to informally resolve the situation. So I certainly don't think the fact that roughly 6 months passed between the notice of deficiency and the administrative complaint is preclusive. And finally, again, with regard to the agency's position that the nursing home should lose because its initial brief did not address substantial injury at all, it didn't address substantial injury because the final order of dismissal did not inform it that that was the basis for the agency decision. And I thank you for your time this morning.
Thank you.